committee. Stayed with us, Bafana Mahungela. Appearances are as before. The Defense Council was still addressing with regard to that. Thank you.
Thank you. The applicant may be seated. Mr. Masako, you may proceed.
May it please, Honourable Court. I'm greatly indebted for the adjournment, for us to familiarize ourselves with the heads of argument. Your Worship, we just about to wrap. And in wrapping, we submit as follows: that this case is nothing else, and in borrowing words from Winston Churchill, Churchill's phrase, I state, this case is nothing else but a riddle wrapped in a mystery inside an enigma. Basically, boils down to what we said earlier on, a riddle which gives birth to another riddle which ends up as a riddle. And why do we say this? We will show as we proceed, but we'll start by saying we refer Honourable Court, because our contention, the point of our contention is that there is no state's prima facie case. And if there is, who gave it? About what? In relation to the charges? There's nothing. In other words, what we are saying is that there is no real evidence which links Mr. Mahungela to these grave offences. There is no documentary evidence. And when I say real evidence, somebody will argue, but the photos were retrieved from somewhere. And they were picked and chosen for a purpose of at least trying to link him up. He answered as to why the two photos cannot be at least some iota of pointing towards his, pure iota of evidence pointing to his, to incriminating him. We submit further, there is no documentary evidence which reads, I say under oath that I saw Bafana Mahungela on the 29th of October carrying a rag with the deceased, and the deceased was screaming. And I wish to draw court's attention that on that wall, which according to the version we have, she was facing the houses. If indeed the killing happened at the park, no one dies in silence. People scream. We do not have an eyewitness, we do not have an ear witness. Let's compare this with what we have in Pistorius. In Pistorius, neighbors come to testify and say, we heard someone screaming. But in this case, no one comes to say we heard anyone screaming. Which points to what? The killing never occurred at the park or at the Sandton, what do you call it? Sandton Convention, not convention, but Sandton Sports Ground. No one hears the poor lady screaming. No one sees. No one smells. We can even speak about all the five senses. It's no, to all the five senses. It's weird. The rag itself. Surely, a sports club doesn't have to have a rag. A rag is something which is used in the house. And it is important to know who came with the rag. Because if you know who came with the rag, it leads you to who killed the person. We said and we submitted that when he came in, photos which were shown selectively did not show him having a rag. No instrument, no screaming, and nothing. Now, what we humbly submit is that the state, in the absence of all this evidence, wants to say the absence of evidence equals to gospel truth. Why there's so much of every item of harmful evidence which they are ignoring, minimizing, and even to some extent trying to attack. We also submit that the state case at this point in time in this bail application is found wanting. It's groundless. It's clutching at straws, and at best flogging a dead horse, hoping that the dead horse will wake up and start to run. And they should be taught this, that when you find a dead horse to be dead, dismount it. That's the best you can do. You can flog it many times. It won't change anything. Flogging a dead horse is abuse of process in court, and it's unethical. It amounts to bad advocacy. As trying to make a mountain out of a mole. The wearing of the t-shirt of the deceased now becomes the murderer. It doesn't work like that. You've got to have evidence supporting such allegations, amendments, or assertions. I wish to remind myself that I said I'm rapping. Yes, indeed, I did read the affidavit I did read the heads of argument. Now, I have already said to this honorable court that heads of arguments, it's unfortunate and regrettable that they do not assist much. One, they don't challenge anything in our heads of argument. Nothing. What they did is just a summary which is riddled with so many omissions, mistakes, and misapprehensions about this case. And we submitted that whoever wrote this must still consult with us at least to rectify the wrong impression which is in the affidavit. And really, to be entertaining these heads of arguments would be at least trying to magnify their importance. I'm not going to do that. However, what I'm going to do is to show where they are supporting our case. Now, if one looks at page 2, they are reading, they say they're relying on 2 affidavits. But the 2 affidavits are relying also on other people which are not mentioned in these heads. IT specialist, private investigator, the father of the deceased, not mentioned. Why? Boggles the mind. Same page. Undisputed facts. Number 2, the victim was killed on 29 during a MyRun event that she was participating in. Clever. They're not saying by Bafana Mahungela. Indeed, because it's not him. Even now, when they're writing this hit, they are convinced that it's not him. But funny enough, the charges still stand. Now they say the victim's cell phone was somewhere at the visit. We don't want to say much about two phones which are referred to by the witnesses, and other one being found in the pathway, the other one in the bushes. It's fine. Those are material contradictions, but it's okay. But of importance is that the victim's cell phone, the accused's cell phone, have been taken to forensics. We don't know. And if whoever was drafting these heads is a citizen of South Africa, should know better that our laboratories are flooded with DNA, with all we are lacking behind. Some cases, I can mention, for instance, Gardi, the secretary for the EFF's daughter, was killed. One of the reasons why that matter had to be withdrawn, it's one, the state witness unavailable, but I think the delay also was caused by forensics. And those gentlemen who allegedly committed the crime were out on bail. Now, if you live in South Africa and you ignore such important facts, then you're surely a somnambulist. You're sleeping in your walk. And a somnambulist cannot help this court. Now, paragraph 6.1 on the same page 2. The accused was at Jodli Park on 29 October 20 during the morning. He was wearing a black t-shirt when he entered the park. We don't know at what time. And my learned colleague came with this tower thing. It doesn't help. You need an expert to tell when this tower was catching him as to where he was. And may Honorable Court take judicial notice of the fact that Sandton doesn't start necessarily in Sandton. Sandton starts in parts of Alexander, Weinberg, and some people call this court Weinberg Court. Now, they won't give the time because they don't know. The accused was at the location where the victim's body was found. It's not correct. You need an expert, and an expert would be in a clear position. You cannot just come up with a piece of paper which deals with galaxies, study of stars, and then assume you know what Neptune or what. You don't. I don't know anything about science. I didn't study any BSc. I studied LLB, and I'm restricted to that. If I want to know more, I then have to read some more on the subject. But somebody who is so empty on the subject comes with conclusions. He doesn't even produce any certificate to say, I qualify myself to be an expert, hence I'm asking these silly questions. We also submitted that, indeed, it is the strongest tower which can show as to where you are. It does not necessarily mean you are at the place. But even if the tower was showing, it doesn't necessarily mean you're 100 meters away from the deceased. Following him. Then, we missed this one. If accused was 100 meters following the deceased, then tell us again, who was 100 meters again following the accused? Cannot limit it to only two people. No, you can't. And tell us also as to how far were the other people who were walking as opposed to the accused and the deceased. No, you can't just pick and choose and think that this sloppy, fallacious reasoning will lead to a sane conclusion. paragraph, page 3, paragraph 6.4, the accused proceeded to remove all the clothing. It must be noted at the stage that that clothing she was wearing is in dispute. No, it is not in dispute. Again, viva voce evidence is clear, crystal clear. The accused person undressed the poor lady out of shock, fear, and frustration, and in his own version continues to say, I then took the clothing to put it in a tray. And question was, why were you putting so that they are not seeable? That's what he said. Now, it is not in dispute. If it's in dispute, it's in another Mahungela case which you don't know. Yeah, now, paragraph 6.6. The victim has passed away by the time. You see now? By the time the accused left the scene. The victim had passed away by the time the accused left the scene. It's supposed to be a version. How was she going to be alive? Because he found him to be dead. He found her to be dead. The accused also confirmed that body had injuries at the time. He said, I saw on one cheek, he was not even sure on which cheek, and even on the neck, something was swollen and so on. Right? We are told that clothing has been taken for forensic. Another issue to be noted by the court. 6.8, we have resolved that disposed the victim's clothing in the storm drain. Now, what is palatable for our version is the following. As far, which has not been disputed, as far as the accused personal circumstances are concerned, the following facts are not in dispute. Our client, they say, does not have any previous convictions and on other criminal matters against him. 7.2, they know where is he staying, and they also know that we provided them with an alternative address. It's not in dispute. Paragraph 8, the accused was presented with cell phone towers, Exhibit K, and did not dispute. No. In S versus Ruode, I should find it somewhere here. The SCA said the following. Issues about expert evidence cannot be put to this accused person who is just a witness of fact, a lay person. Even the prosecutor, if I can put him in there, he won't answer me on the 10 questions which I can pose to him. So we need experts to be dealing with this thing. And we urge the Honorable Court not to crucify our client for not having knowledge about things which needs some expertise. The accused took a photograph with his cell phone. How can he take a photograph with his cell phone? Because when he said, I am not sure about the times as to what time I arrived at the sports club, at what time, the only reliable source is my phone, which is in the possession of the police. Now, you see, that's why I say mimicry is a problem. Copying and plagiarizing things which are not yours and pretend, we can catch them. Some of us know these things. We know them. Which photograph are they referring to now here? This photograph was not taken. They never got any information from a client's phone. And let me then jump and move to applicant's case, paragraph 4. He fell asleep and was dropped off somewhere in Parkmore after he woke up. He was not dropped somewhere. We gave, in our photos, we showed a Google map which shows that where he was dropped, and it's a street, yeah, it's 11th Avenue, and he just walked 8 minutes. It's approximately 8 minutes walk. And then he said, yes, indeed, it could have been, they say 9 to 9:20. He never said that. He said it could have been 9 to 10. At some point he said 9, 9:30, and he said to 10. But I am not sure. The photos which I took, which are in my phone, because they will show at what time I was there. Now let's take this part and see how many times we're given. 7:45, 8:05, 10:03. Now we've got a new time, 9 to 9:20 in the heads of argument by my learned colleague. So who becomes a new witness in the space? They've forgotten about the 8 minutes. And the 8 minutes walk, a question was asked, did you have an intention to murder, rob, rape anyone? No. Was that challenging cross-examination? Not at all. We submit. Paragraph 8, whilst on the jogging trail, he stopped to urinate next to the path, as if they were there. He said pee, not urinate, in fact. Pee. It was unclear from this testimony whether he stopped right next to the... Oh, you see, it was unclear from his testimony. He was clear. He stopped right next to... He spoke about a jogging trail. And that's where he saw the body. Down there, he said. Doesn't matter as to what is the distance. And if they were there, had their tapes, they could have measured. I now move to page 5. On paragraph 11, he turned the person around by pulling her with both arms, placing this one, the honorable magistrate has dealt with. And he testified he did not notice any other injuries to the face, head, or neck. Look, it's for the experts, and they are not experts. Then he checked the pulse. They're agreeing with us and so on. Your Worship, much of what they're saying is in agreement. But I need to draw to court's attention the following. Paragraph 20, my learned colleague says, after 2 days he told the residence caretaker partner, Norma, about what he had seen. And then he paused, he said, Norma, who's a divorced lawyer. No, he said he's a divorced lawyer. She's not divorced. If he knows about this divorce, well, it's new evidence for him. Now, Your Worship, paragraph 21. This is problematic in that it reads, he never reported any of the above to the police and remained in Parkmore, where he was staying during his studies, whereas this incident was on the media the very same day. In cross-examination, even on the affidavits, no one says it was on media and this accused person saw it on media. It could have been on media, but no question along those lines were put. And even the affidavits are not referring to the media. Another concoction. Now I move to it was put to the cross-examination, paragraph 23. It was put to the accused that he did not remove the phone from the scene as he knew it could be tracked easily. The accused stated he could have solved the issue of the phone tracking. No, I think, I don't know. What the accused said, I have my phone, I had no reason to take the phone, and even if I were to take it, I've lost so many phones. People go to some Indian shops and they do this to do away with, it's tracking. If I wanted, I would have taken it and behave like them. I'm seeing it always on some media platform, isn't it? Yeah. Now, this is misrepresentation of facts. In fact, it's tantamount to fraud. And it's not only misleading, it's fraud. I'm not going to read the whole thing, but much of it will show that DNA, forensic laboratory, still has things, phones and so on. Telecom towers, we need experts to deal with that. Yeah, this one is important. On page 8, re-examination. The accused was handed further pages from the provisional post-mortem. One, we are not told when is the final report coming. The state relied on this provisional report in saying, for the very first time in cross-examination, that the deceased was pregnant. Hence, we then requested it, because that was their basis, and we couldn't have left it unchallenged. So now to turn around and say it's provisional, it's shocking. We submit. It's quite shocking. Law of evidence doesn't simply, the fact that bail is not strict on rules of evidence doesn't mean you just come with a contradictory version, which is a hodgepodge, and just throw it to the court. Van Days says there. Contradictory hodgepodge. It's a mess. Now, they say it was produced by his legal representative. They do not say in cross-examination. They're the ones who open up the door. Because they say, I put it to you that she was pregnant. And then I said, shape objection, pregnant based on what? We've got the proof. It's in our docket. We know our docket. And knowing that docket produces this provisional report, now it's not their own. They still have to wait for something else. They want to lay their bed and lie on it. They say now they want a state pathologist. Should this court now adjourn for them to go get the state pathologist report? But they don't dispute the fact that there are no obvious injuries to the genitals. Nothing stopped them to call Pretoria and get someone to say, come and testify. No obvious injuries to the genitals means rape has occurred. Nothing. We submit that at these times which were given, 806, 818, which are on page 9, it's just a summary of speculation, conjecture, and unfounded assumptions. Now, let's look at paragraph 3. Paragraph 3, this summarily, casually, Sergeant Chisani, the investigating officer, also deposed to an affidavit in which he sets out how the accused has been traced and the grounds on which he submits that the accused must not be released on bail. They don't mention them. They're saying 1.4 kilometers. He could be stalking. We're simply saying we cannot simply rely on what the IO have said. He is saying that after failing to achieve incriminating evidence by hitting our clients. So in fact, even his affidavit should be looked at with great caution and circumspection, that this man who has failed the Constitution has an axe to grind with the accused person, because the accused person didn't give him what he was expecting, incriminating evidence in the form of admission and confession. Having spoken about a confession and admission, I then submit as follows. All the charges preferred against the accused person, we emphasize emphatically that they hold no water, no matter how serious they are. So therefore, what are we sitting with? We are sitting with a Schedule 6, which amounts to absolutely nothing, due to lack of evidence, be it direct or circumstantial evidence. And I think I said, did I mention R versus Blom? That is not applicable in this course, but yeah. Now, admissions which we made, and we are not asleep when we make these admissions. Well awakened, aware, and attentive to the fact that clothing which was in the drain, which my client admitted to taking, was taken back by the private investigating officer and the IO. The only thing which they couldn't find is the t-shirt. And we said, well, I asked the accused person about its price tag, which was not disputed. She said it could be 200, 250. Now, having submitted that this Schedule 6 dies a natural death, what are we left with? And I'm an officer of the Honorable Court, who has been a prosecutor for years. We are left with theft. And why do we say theft? Theft is the intentional and unlawful taking of an item belonging to another person with the aim to deprive them permanently. Now, the question to be asked, did the state get the t-shirt back? No. Elements of theft satisfied? Yes, at least for now. Taking into account that we have no access to the docket. And or defeating the end of justice by doing what? Interfering with a dead body. My learned colleague never said, we want to prefer them. He in fact agreed. At some point he asked about the t-shirt and agreed that, yeah, theft and not defeating the ends of justice. In their heads, they don't say anything whatsoever about that. Now, one other crucial thing which they do not mention is that in the affidavits of the two witnesses, they refer to almost 6 or more video footages. But they don't say to this court, play open cards and say, Honorable Court, we can't show you this video footage because it's privileged. We don't want you to see it. Or maybe, let's do away with the defense. Let's show it to you secretly. They don't do that. They don't have it. We submit. Now, grounds for Chisane are groundless, and if one listens to I think the security does not give any grounds for refusal of bail. And it's for a good reason, because he knows there's nothing. This gentleman deserves to be out. So we use the affidavit of the security to contradict that of the IO, even in its weakest state. The IO's affidavit is weak on the grounds of refusal. It's tantamount to no refusal. Yeah, I see on page 9, they say it's a commendable effort. I appreciate it, and I wouldn't say much. Thank you for that. I have dealt with, yeah. they say we've been selective when they are the ones who are selective. Expert. Now, Your Worship, I now come to my conclusion. Now, I say in my conclusion, after a lengthy critical analysis of evidence, we urge the court to find that in search of truthfulness, we remain with a mystery unresolved. The vital clue is missing. We ask the following question, rhetorical questions, which up to now are not being answered by the state, which is armed with a docket, with statements and everything. We ask the following rhetorical question. Why are so many video footages, which are 6 or more, not shown to the court? We submit that it is considered truth. It is not only a hopeless story, but a story which is doomed to failure. And we also add by saying it's bizarre, fictional, improbable, and unbelievable, a conundrum. No eyewitness to the event. Evidence of meeting deceased death remains unchallenged. There is no motive shown by the applicant to murder or pre-planned or not. And same with robbery and other charges. Character evidence has shown a clean record of the applicant beyond reproach. Circumstantial evidence shows that applicant did not know the deceased. Medical M1 and M2 supports one version of the applicant. 1003 and no forensic evidence still outstanding, save for the post-mortem, which supports our version about the time and cause of death. And then we submit further. We submit. A panic-stricken person is prone to behave in a manner demanded by the situation at hand. The character of the deceased, especially the pregnancy, was not investigated. As I said earlier on, was she in an extramarital affair, married, or had a boyfriend? Where is her car? The wearing of a deceased T-shirt is an unsatisfactory and tenuous basis for the arrest and subsequent detention under Schedule 6 or 5 or 1. The two disputed questions at hand are, did we show any exceptional circumstances? We submit we did. Are these exceptional circumstances in the interest of justice? We submit indeed. Now we humbly submit that the court finds that indeed the accused is a suitable candidate to be admitted to bail. And we further submit that his release on bail doesn't cut this matter from going to trial. Further submit bail conditions are there to safeguard accused released from fleeing, which is far-fetched, removed, and non-existent. We submit that at all relevant material times, family of accused was in court. He's a South African, and it shows that he comes from a non-defective upbringing. And I wish to also draw attention to what the school said about him. No, the school's principal. I'm sorry for those who are impatient with me, because I might take ages by saying that concludes my heads of argument.
Good. The court will then adjourn until 2 o'clock and then proceed with the judgment. Court adjourned.